Hello students, welcome to Legacy IAS Academy. In today's video, we are going to discuss about a recent news that has come for the government employees, where government has now said that the employee who belong to the central government sector, they can participate in the RSS, that is Rashtriya Swayamsevak Sangh activities without incurring any kind of penalties as applied before. So, what does the new rule and new circular released by the Department of Personal Training says? We will try to understand this in more detail. So, first of all, to give you the background of the topic, the central government has decided that the mention of RSS, Rashtriya Swayamsevak Sangh, as an organization that government officials cannot be part of should be removed. Now, this bar on official participating in activities of this RSS was first brought into effect somewhere almost 6 decades ago, somewhere in the 1960s, and following a directive that was issued by the Department of Personnel and Training earlier this month, employees can now participate in the activities of the RSS without attracting disciplinary action, which could have been possible last before the circular came into effect. And this is something that is applicable for the conduct rule of civil services as well as all India services. So, if we try to understand this about the directive that has been issued. So, directive has been issued by the Department of Personnel and Training, which is a department working currently under Ministry of Personnel, and it manages the central government's human resources. So, the circular said that it has reviewed the earlier directive issued by the government ministries, where instruction was issued in 3 years, 1966, 1970 and 1980, and on the basis of this review, the department has decided that it will remove the mention of RSS from the impugned OMs. OM means official memorandum published on 1966, 1970 and 1980. So, before understanding the new circular, let us try to understand the circular that or the memorandum that this circular is trying to abolish. So, it was in the month of November 1966, the Ministry of Home Affairs, under which that time DOPT used to work upon, now DOPT, as we have discussed, has been brought under Ministry of Personal Public Grievances and Pensions. So, it issued a circular. The circular stated that government policy with respect to the membership of any participation in the activities of two organizations that has been named here, one was the RSS and other is the Jamaat-e-Islami, by the government servant is something that will not be allowed. The activities of these two organizations to be of such nature that participation in them by the government servants would attract the provisions of sub-rule 1 of rule 5 of the Central Services Conduct Rules that was published in year 1964. Now, what were these rules and sub-rules? So, first of all, any government servant who is a member of or otherwise associated with the aforesaid organization, that is RSS and Jamaat-e-Islami, with their activities or they are involved in any of such activities, they will be liable to have a disciplinary action taken by the department or ministries against them. In this case, rule 5 and sub rule 1 clearly states that no government servant shall be a member of or be otherwise associated with any political party or any organization which takes part in the politics, nor shall he take part in, subscribe in aid of or assist in any of other manner any political movement or activity. That means basically, as per the rule and the two organization that has been included here, government wanted to clearly give a message that the activities of RSS and Jamaat-e-Islami can be considered to be of political in nature. And since political neutrality is one of the major, we can say, qualities or major qualification that is something that is associated with a civil servant, that is why their involvement in the activities of the organization is something that has been prohibited. The All India Services Conduct Rule 1968, which applies for the officers of IAS, IPS as well as the Indian Forest Service, has a similar rule as of Rule 5 sub Rule 1 as we have discussed. That means all the employees of central government basically are bound by this particular rule. Now, what was the rationale behind implementing such rules and bringing these two organizations under this list? So, obviously, the need, as given by the minister at that time was to ensure a secular outlook on the part of government servant, obviously because India is a secular country. Not only that, it also states that the reason behind such kind of prohibition is with the need to eradicate communal feelings and communal bias which can be crept into the working of the civil servants if they participate in such organization, and this is something that has also been overemphasized. So, in one way we can say to ensure the political neutrality of the civil servants, to ensure that they have a secular outlook while they are serving the country, discharging their duties, and also they are free from any kind of religious or communal bias, enforcement of such rules were deemed to be necessary. However, any disregard of this instruction should be considered as a serious act of indiscipline, and government circular clearly stated that suitable actions should be initiated against erring employees. Now, what was the situation before 1966? Because as we have discussed, this prohibition came first time in the year 1966. So, even if you look at the time of 1949, that means just 2 years after the independence of India, when Sardar Vallabhbhai Patel was the Home Minister, that time government brought a rule called as Government Servants Conduct Rules. It was framed in 1949, and in this act or in this rules, the rule number 23 says similar things as has been given in the rule 5 of 1964 and 1968. So, it says that participating in the political activities is prohibited, obviously because political neutrality is required for government employees. Now, what kind of organizations has or can be considered as a political organization, that question has to be clarified from time to time as per the requests and representations to the government. And in this context, if you try to understand, the penalties were also clearly stated that Rule 5 Sub Rule 3 of 1964 says that if any question arises, now first of all we are talking about that which organization can be included or not included in this rule. So, this question has to be decided by the government itself, and the decision taken in this regard by the government thereon shall be final. Also, in the most serious cases, it states that official concerned, if they have been involved in activities or directly and indirectly associated with the organization that is prohibited under the rule, they may be dismissed from the services altogether. Now, since the RSS does not have a system of formal membership, it is difficult to establish an individual's association with it. So, even if indirectly someone is associated with RSS, unless and until there is a clear evidence or implications, he or she cannot be dismissed from the service. So, that is something that was at the practical level. Now, the new circular, as we have discussed, removes RSS from the list where we have RSS Jamaat-e-Islami. Now, significance is what? Obviously, indirectly government is trying to give a message that RSS is not a political organization, and the central government employees can now take part in RSS activities without fear of attracting action. That is the most significant outcome of the recent rules. Now, crucially, while the 1966, 1970 and 1980 circulars mentioned Jamaat-e-Islami as an organization of political nature, the recent circular removes the tag from the RSS only. That means, if anyone is associated, anyone means we are talking about the central government employees, if they are associated or associate themselves with the Jamaat-e-Islami, then obviously the rule will apply over them and the disciplinary action can be taken against them. Also, it means that the Jamaat-e-Islami still remains an organization whose activities are categorized as political nature and government officials cannot take part in them. Now, this is something that is related to the central government employees. Now, what about the state government employees? So, obviously, this circular is not applicable to the state government employees because each of the individual states are free to frame their own rules related to this. And in this context, if talk about state government, they have their own conduct rules, and numerous times the state government have changed their rules from time to time based on whichever party has come into power. So, in this regard, we can take 3 examples. In the case of state of Himachal Pradesh, when the P.K. Dhumal's BJP government came into power, it already has withdrawn the restriction on its employees from participating in RSS activities. Similarly, when the BJP government were formed in the Madhya Pradesh under the chief ministership of Shivraj Singh Chauhan, it also issued a clarification saying the restrictions are not applicable on RSS for the state government employees. Before that, when the Congress government was in power in the state of Madhya Pradesh, such restriction was imposed on the state government employees as well. Third example we can take of the state of Chhattisgarh, where when the Raman Singh came into power under the under the BJP, he also issued a circular saying that there are no restrictions on government employees who want or are taking part in the activities of Rashtriya Swayamsevak Sangh. So, based on the numerous states that we have in India, each of the states are free to frame their own rules, free to put the organization which they want to restrict participation to from their employees. So, that is all about this particular video. I hope you understood about the recent rules related to the association of the central government employees with RSS and the overall implications of this. Thank you very much.